Every business comes across commercial contracts. Hello, my name's Stephen Mather, Solicitor, and I help small business owners with a wide range of legal problems, from startup to exit and everything in between. There can be a wide range of different things. So it could be your own terms and conditions, right? That's a commercial contract as far as I'm concerned. So your dealings with your customers. You'll have suppliers, so either working on your contract or their contract. You might be entering into a joint venture with another company. You might want to engage with sales agents. You might want to grow your business through distribution or franchising. All of those require contracts. The idea behind a contract, as far as I'm concerned, is to provide as much certainty between both parties as to what we're all doing. And that's really the fundamental. So a contract needs to set out who the parties are, what the responsibilities, the obligations on each party are, and then really kind of what happens if it goes wrong. And it's really important to, when we're looking at contracts, to treat them as, I always term it as a backstop, something that hopefully you're probably not going to look at again. But if you do, you want to make sure that in black and white it's there. If I look at terms and conditions as an example, lots of people overlook terms and conditions. But they are really important, particularly if you're dealing with businesses. If you're dealing with consumers, they're important, but you're restricted generally because consumer laws apply. But with businesses, you can have terms and conditions, and the law says, well, if you've written it down and both parties have agreed, then that's what it is. That's the agreement. So you could have, in theory, something really silly to say, we only pay invoices that arrive on a Tuesday on yellow paper, and otherwise we don't pay invoices. And that's legally binding. You can do that. Within a contract, we can write whatever we want, as long as both parties agree. Clients will always ask for whether or not a contract is watertight. Can't guarantee that, right? Can never promise that a contract is completely and absolutely watertight, because ultimately, if there's a dispute about a contract, it goes to court and a judge is going to rule one way or the other on it. What I can do is bring my many years of experience in terms of dealing with disputes and courts and contract drafting to make sure that the contract is as good as it can be, as secure as it can be, so that if you need to rely on it, you can do. Now, in an ideal world, you don't rely upon it, because what you do is you have customer service. So you have an issue and you're dealing with a customer and you say, okay, yeah, look, I can refund you, or I can deal with it in this way, we'll give you credit or whatever it might be. Nothing to do with the terms and conditions or your contract. But when it does turn sour and things don't pan out as well as you expected, in an ideal world, what you want is a good written contract that says this, this, and this, so that you can go back and say, actually, no, you've broken the contract. We are now entitled to X, Y, and Z for our losses, and you now need to pay us. I spent quite a lot of my career dealing with disputes, contract disputes. And what that allows me to do is have an insight from how a court would look at it in the event that there's a dispute over a contract, there's a breach of contract. Let's have a look at how the court's going to have a look at it. Whereas most contract drafters, solicitors, lawyers, whatever they might be, don't have that level of experience. They might be able to write the words on the page, but not necessarily have that experience and knowledge and understanding of how a court might look at it. So I'm always going to approach contract drafting in two ways. One is that they need to make sense, right? So it needs to be readable. So we'll engage with plain English as best we can, make sure that it's clear and understandable between both sides what each is doing, but also then to protect my client if the worst happens, the worst being there's a breach of contract. So I think what makes me different on drafting contracts is the approach that I take. I'm not just looking at this as a contract. The words on the page, they're really important, but it's the consequences of that, what might happen, that we need to have a look at. I think as well, I bring a slightly different approach to contracts because I'm not just a contract drafter, because I'm a business lawyer and I advise lots of businesses around a variety of different things. It's being commercial and pragmatic. So if you are on the receiving end of a contract, then absolutely you take advice immediately. You're going to get me to review that before you sign anything. If you are exploring any kind of relationship with any third party, whatever that might be, as a customer, a supplier, or any other third party, I think the right time to speak to a lawyer is certainly before signing anything, but probably after you've worked out what the general terms look like. There's thousands and thousands of legal cases in the courts on a daily basis in this country, and almost all of them are about contracts. And most of those ones that are about contracts are about unwritten contracts. He said, she said, this is what we agreed. No, we didn't. And without any evidence of what was agreed, it becomes really difficult to bring a claim, because you've got only your evidence and the other person says, no, we didn't agree that. That's not what we said. You said you were going to do this. So having a contract for any kind of engagement with a third party is really important, because it's documenting what we did actually agree. So the worst outcome to not having a contract reviewed, written properly, is damage to your business reputation, cost, bottom line, it hits your profit. Having to go to court, well, that's going to cost a huge amount of money to have to go to court, lawyers' fees. Gambling at court, and frankly, that's what going to court is often about, gambling. It's flick of a coin, it's black and white. A judge makes a binary decision, it's either for or against. A contract, it doesn't exclude all of that risk completely. There's still written contracts where there's disputes over, can't guarantee and rule out any kind of litigation completely. But having a well-written contract that covers everything that we need to cover puts you in a much better place to not have to worry about those risks.